All right, so greetings, participants. I'm Vaibhav, an executive member at Legal Vidya, and it's my pleasure to welcome you all to our highly anticipated webinar on an overview of intellectual property laws. So, intellectual property laws are the backbone of innovation protection, safeguarding creations ranging from inventions and designs to literary and artistic works. Join us as we delve into the intricacies of patents, trademarks, copyrights, and trade secrets, providing invaluable insights into how these legal frameworks empower creators and businesses alike. Whether you're an entrepreneur, artist, or a legal professional, this webinar promises you to demystify IP laws and equip you with the knowledge to navigate the ever evolving landscape of intellectual property rights. So, this webinar is an excellent opportunity for legal professionals, business leaders, and academics to deepen their understanding of IPR in India. So, before we delve into the webinar, allow me to introduce Legal Vidya. Founded in 2021, Legal Vidya is dedicated to empowering young lawyers. Our platform offers a comprehensive portal for enhancing legal knowledge and expertise. We provide internship programs, opportunities to publish articles, and host interactive webinars and sessions for our members. Before beginning, let me just introduce our host. So, Dr. Kavya Chandel is an assistant professor at Integral University, Lucknow. With a rich academic background and a passion for law, Dr. Chandel brings over 3 years of experience in academia, having previously served at Amity and City Academy Law College. Dr. Chandel's expertise shines through her educational journey, culminating in a master's degree from Hidayatullah National Law University, Raipur, specializing in environmental law, and a postgraduate diploma in intellectual property rights from Ram Manohar Lohia National Law University, Lucknow. Her commitment to environmental issues is further underscored by her PhD in environmental laws. So I kindly request you all to keep your microphones muted and videos turned off during the session. And if you have any question, please save them for the end when the speaker invites you to ask. So without further ado, let's warmly welcome Dr. Chandel to the virtual stage. We eagerly await the invaluable wisdom and perspectives she's about to share with us. Over to you, ma'am.
Thank you so much, Mr. Weber. Thank you so much to the entire team of Legal Vidya for inviting me on this platform where I can share my views and perspectives on the intellectual property rights. IPR is something which is not only even exciting, but it's also even intriguing for a person to explore and enhance opportunities in intellectual property rights. So just give me a second. Meanwhile, I'll share my PowerPoint presentation with you all and we'll have a discussion of the same. Okay, is my PPT visible to everyone? Mr. Weber, is my PPT visible?
Oh, yes, ma'am, it is totally.
Okay. See, when we talk about intellectual property rights comes under certain ambits, and these ambits have been divided as. See, first of all, we have geographical indications, industrial designs, we have patent, we have copyright, we have trademark. Within such heads, it defines about intellectual property rights. But what is IPR? The concern is that what is IPR to one's notion, one's understanding, one's building. See, IPR, when we talk about intellectual property rights, basically it's an intellect or understanding which is given to a person to create a right, to explore the right, to enhance the paradigm of the certain right. When we talk about the historical background of the intellectual property rights, so it is the World Intellectual Property Organization, which was established by WIPO convention in the year 1967. So it basically started with the established organization, and it has been established by WIPO convention. The historical background also states that there has been a specialized agency of the United Nations. So WIPO has been considered World Intellectual Property Organization, which is now known as WIPO, has been the specialized agency of the United Nations. And the major role of the WIPO is to protect and promote the intellectual property throughout the world. So, intellectual property right, the basic aim of the intellectual property right, the basic aim of the WIPO, the basic aim of the IPR is to protect the IP rights not only in one particular nation, but each and every part of the world has to be embedded with the right, has to be very much assured with the right, and its headquarters are basically in Geneva, Switzerland. So, World Intellectual Property Organization, WIPO, has been headquartered in Geneva in Switzerland. As we know the fact that we celebrate the World Intellectual Property Rights Day on April 26th. So, in each and every year, we celebrate WIPO on April 26th. Now, moving ahead and switching to the next slide, that talking about it, why intellectual property right is important, that why protecting and promoting the understanding of the human intellect is important. Human intellect has been the very primary notion of protecting the right which are in specific areas, be it artistic right, be it literary right, or be it like protecting the scientific creation. So artistic, literary, technical, or scientific creation has been protected under the ambit of intellectual property rights. So the original creativity, the original boost of mind, the original understanding of making sure that like how is IP protected and why it is important to protect the IP. So artistic, literary, and technical works and as well as the scientific creation are protected and promoted under intellectual property rights. Whereas when we talk about IPR specifically, there are certain legal rights given to an inventor or the creator and exclusive rights given for a certain period of time. So there are certain rights, be it like copyright, be it like patent, be it like trademark, be it like geographical indications. There are exclusive legal rights given to the creators, given to the originators, to whom the basis, to whom of the understanding of the creation of the right has been given the onus of. IPR not only you can say that it protects and promotes the economical development of the country, but it also promotes the industrial and economical growth. So you can say that not only the intellectual growth or intellectual ability or understanding has been protected and promoted, but also the economical development and industrial and economical growth has been given the equivalent advantage when it comes to intellectual property rights. So intellectual property rights, when we say about like what is invention, like talking about that if somebody is creating something, if somebody is innovating something, if there is an idea, if there is an understanding, then what is invention? See, invention means a new productive process which involves an inventive step and capable of industrial application. It's a concept of new ideas. See, whenever there's an innovation, whenever there's an invention, there must be a proper inventive step taken on part of the inventor, and also such industrial application must be put to at least have a utility. Without having the utility, without having the source, without having the advantage, without having the due course, the utility cannot be maintained. So whenever there is a product, whenever there is an invention, whenever there is a process, that invention, that process, that application must have a certain utility. It must have a certain usage. It must have a certain ability. And also it should not be futile in nature. Whereas when we talk about innovation, innovation is an application, adoption of the idea, that is the product that moves the idea into a marketplace. So whenever there is an innovation, whatever the product, whatever the invention, whether there is a drug, whether there's a scientific application of the progress, whether that particular innovation, whether that particular progress is being somehow creating the advantage to the market or not, whether that particular product, whether that particular thing is given any kind of advantage, whether there has been economical growth or whether there has been any kind of industrial growth or not. So these are basic factors which are very relevant when we are taking or addressing the questions related to innovation. But what is patent? See, patent is to be provided by the government, right? Patent is something which is to be provided by the government, and it has to be an invention, excluding from the making, using, or selling the product or process. So whenever there is a patent, whenever there is a patent which is to be granted, it has to be granted by the government, right? And that product, that invention, that making or using of the product must have a certain applicability, must have a certain industrial application, must have a certain usage. If there is a usage, or if there is a utility, or if there is an industrial and economic growth, then the patent is to be granted. Now, moving ahead, then what is copyright? See, copyright has been basically granted for literary works, for artistic works, and for the dramatic works. And that is for the period of minimum 50 years after the death of the author. So once who is the author, who has created any book, who has written any book, who has written any document, any prepared any document, who has contributed in any kind of literary activities, then after his death, for the period of next 50 years, that person is to be granted the copyright. Now, moving ahead to what is trademark. See, these are the ambits, these are the important applications of intellectual property rights. Trademark, you can be trademark is something that can be characterized as a distinctive logo, as we have seen the logos. So you can say that the specific logo, the specific sign or a design has been granted under the ambit of a trademark. We'll discuss the examples of copyright, patent, and trademark in the very next slide. Now, moving ahead to the next slide, that why intellectual property law is important in the ambit of India. Okay. When we talk about intellectual property rights try to protect the various ambits. So there are books, there are paintings, there are musical compositions, there are plays, there are movies, there are performances, or the artistic works. These are basically to be protected under the ambit of intellectual property rights, depending upon that which category it has been falling on. So we have this specific category of the copyright where all the books, paintings, musical compositions, any kind of literary work, artistic work, or the dramatic work has been protected under the ambit of a copyright, right? So meaning thereby there has to be industrial property which describe about the physical matter or the concept of the commercial purposes. And they are to be protected by be it like patented objects, or be it like trademarks, or be it like industrial designs, or be it like trade secrets, or be it like geographical indications or layout design. Every ambit is to be protected under the ambit of intellectual property rights. So you can say that intellectual property rights is a major domain where it tries to protect all these kinds of rights, be it patent, be it copyright, be it trademark, be it GI, or be it like industrial design. Within the larger ambit, it tries to protect and promote all these rights under the intellectual property rights. Now, moving ahead, that there are certain types of IPR. IPR consists of certain types. So, when we talk about the major types of the IPR, so we can say that the functional and the technical inventions or the Patent Act 1970 was amended in the year 1999, 2005, and also there are certain amendments which has been laid down. So you can say that whenever there is an intellectual property rights, or like whenever there is a copyright, whenever there is a patent, whenever there is a trademark, so there is a specific year denoted that when these amendments had taken place under the ambit of intellectual property rights. So there are specific years which has been very much clearly and very consciously mentioned, that in which particular year that trademark, that patent or copyright has been amended. Now, moving ahead to the very next slide, that is GI. So we are going to start with GI. Like everybody has heard about there is a logo to it. There's a picture to it. So in this particular picture, you can see the saris from Banaras. So you will find that there is a specific tradition, there's a specific acclamation given to GI when it comes to the saris from the Banaras. So GI talks about that the product must have a specific origination, must possess certain qualities. So GI not only talks about the specific origin, it not only talks about that it possesses certain qualities or a certain reputation that where that particular product belongs to. So you can say that like saris from Banaras has been acclaimed the GI. So geographical indication has been given to the saris of Banaras. So GI is a sign. GI has been treated as like a sign which is used on the products that have a specific geographical origin, and it must possess certain qualities, like the qualities of the sari, the qualities of the Swiss watches, or you can say that the qualities of a particular origination of the product is to be reflected in the form of a GI. See, when we talk about GI, it must identify a product in a given place. So it is very important that GI must be introduced, must have a certain place, must have a certain origination, must have a certain background to it. Okay. Also, GI is a sign which is used for a specific geographical origin, which must necessarily contain certain amount of qualities or reputation. As we can see that the Swiss watches are very much famous in Switzerland, and the saris of Banaras are very much famous in Varanasi, are very much famous in Banaras. So you can say that there is a certain product which is to be given to a certain area or a location or an origination. That's how the product is being like getting the popularity, it is getting the qualities or the origination, because it has been associated in a particular area. Also, in order to function GI, it must identify that a product has been originating in a given place. So if it's a product which is not originating in a given place, we cannot claim that product to be GI, because GI is to be given to a product which contains certain qualities, and it has to be given to a product which belongs to a certain area, which belongs to a certain place. In addition, you can say that it must necessarily possess certain qualities, or it must certainly possess certain reputation which can build up the market. Okay, so that you can say that due to the place or the origination of the product, there must be a clear linkage between the original place of the production and between the product. So is that particular product which you have claimed for the GI, is it the product being belonging to a certain geographical area or a certain geographical location or not? So it is very, very important that that particular product, that particular location must be considered in the form of a GI if it has to be acclaimed as geographical indications. Now, moving ahead to the very next slide of GI, that what is the benefit of geographical indication? Why we consider that geographical indications are important? The first and the foremost, that it confers legal protection. Okay, so whenever if there is a saris from Banaras which is claiming that it belongs to a certain locality or certain origination, then obviously Kolkata cannot claim a GI on the saris of Banaras. Okay, The Banarsi saris belongs only to Banaras. The Kolkata or any other states cannot claim West Bengal or Uttar Pradesh, or you can say that Maharashtra or Gujarat cannot claim the geographical indication on the particular saris of Banaras. So it is very important that if there is a locality, if there is a origination, if there is a certain sign to it, that particular product must belong to a certain origin and it must possess certain qualities which are necessary for giving the benefit to the market. Now, secondly, it is very important that it prevents the unauthorized use of the registered geographical indications by the others. So it should not be hampered because of the certain territory. It should not be hampered because of the geographical location. If there is a certain product which belongs to a certain area and this product, if it has been granted GI, any other state cannot claim GI on that particular product. So that's how GI is to be given the protection. Now, it also promotes the economic prosperity of the producers of goods. So it is very important that not only the producers are, not only the consumers are getting the advantage, it is also equivalently given the advantage to the producers. The producers who are producing the product in a certain area, they are to be like given the acknowledgement. The cost has to be boosted up, their reputation has to be boosted up. Also, we need to boost up the export. So like exporting, also creating the prosperity to the producers are the major areas which we as a consumers, which we as a producers need to focus upon, and that has to be done by the part of the government. Now, GI, you can say that it not only a source identifiers of the consumers, but it also tries to protect the consumer loyalty. So if the consumer is being particularly loyal to the product, if it has created the product, then it has to be, if the producer has created the product and if the consumer is enjoying the benefit out of it, then I'm sure it is very certain that the consumer is taking the advantage and the consumer is loyal to the producer. So both the producers and the consumers have been loyal to each other. So it helps the producer to develop the consumer loyalty. If there is a certain reputation, you can say that if there is a certain kind of necessities, if there is a certain kind of reputation which has been attached to a particular product, then from now onwards, that particular products get the reputation, get the understanding, get the prosperity in the market. And it is also equivalently important for the consumer to protect the loyalty. So both the consumers who are enjoying the product and the producers who are producing the product are loyal towards each other. For example, you can say that geographical indication is very much important in a component of wine pricing. So wine pricing, or you can say that there are certain other products such as basmati rice, Mysore silk, you can say that Mysore sandal soap, even you can say that the Darjeeling tea, Dharwad, Pedha, also Alfonso mango. Now, these are some of the geographical indications: Banarsi saris, basmati rice, Mysore silk, Mysore sandal soap, Mysore jasmine, or you can say that Madhubani paintings or Darjeeling tea or Alfonso mangoes. Like these are certain very quintessential examples of geographical indications in India. So GI, you can say that on these particular products, GI has been granted upon. Now, moving ahead, that there are certain examples of GI in the world. So like Canadian whiskey, Swiss watches, as you just discussed about, Florida oranges, champagne and tequila. Now, these are some of the specific areas where GI has been specifically given the acclamation, specifically given the kind of recognition and the acknowledgement to these products. So these products are basically the GI originated products. Now, talking about what is geographical indications in India. So like in Indian context, if we talk about in Indian context, India has been the member of previously the World Trade Organization, which has been enacted under the Geographical Indications of Registration and Protection Act 1999, and now it came into force from the year 15 September 2003. So if there's a question like if India has been the member of WTO or not, then India has been the member of WTO and it has enacted the GI Goods Act 1999. So GI, Geographical Indication of Goods Act, Registration and Protection Act 1999, it basically came into force and has been enacted, and like the effect was given from the year 15 September 2003. So like the act was basically enacted in the year 1999, and afterwards it came into enforcement from 2003 onwards. Also, the central government of India has established the geographical indication registry with all India jurisdiction in Chennai. So you can say that the central government, which is equivalently responsible for the same, has GI geographical indication registry as its office with all India jurisdiction in Chennai. So we have the GI registry India. The office has been situated in Chennai. Also, GI Act has been administered like and controlled by Controller General of Patent, Design and Trademark, who has been considered as the Registrar of Geographical Indications. So basically, GI Act has been given the registrar. GI Act has been administered by the Controller General of Patent and Design and Trademark, and he has been considered as the Registrar of the Geographical Indications, right? So till now, do you have any of the questions? Okay, PPT in full screen. Just give me a second.
Please wait for 2 minutes. There are some connectivity issues. Kindly stay.
Just give me a second. I'll again share my PPT. Is my PPT visible?
Yes, ma'am.
Okay.
Ma'am, it
Now,
is.
okay, thank you. Now, talking about geographical indications when in context to India, so agreement on TRIPS was being made. So, agreement on trade-related aspects of intellectual property rights in the year 1994. It came into existence 1994, and there are two obligations of World Trade Organization as a government relating to GIs in relation to TRIPS agreement. So there are certain obligations which are like twice in number. So there are major two obligations which on the World Trade Organization member government related to GI in relation to TRIPS agreement. So that is in relation to Article 22 and Article 23, which talks about prevent the misleading public as to GI origination of the good. So Article 22 specifically states that we need to prevent the public who is being misled due to geographical indications in origination of the particular good Also, Article 23 specifically states that we need to prevent the use of geographical indications identifying wines not originating in the place. So it's very important that the certain product must have a certain origination and have a certain quality in which is to be come into existence. We cannot, say that certain product belongs to a certain area, not claiming that it is not a GI. So it is very important that that particular product, it should not mislead the public. The public should not be hampered in the origination or the the quality or the good of that particular product. Also, when we talk about the trips, now moving ahead, like I just hope that GI has been clear to everybody. Now, when we talk about the trade related aspects to intellectual property rights, that is TRIPS. So, TRIPS is an international legal agreement between all the member nations of WTO. So, WTO members have been the part of the TRIPS. Okay? So, like TRIPS is an international agreement between all the member nations of World Trade Organization. So, World Trade Organization members and the TRIPS members, international agreement has been created. So TRIPS is an international legal agreement between the member of the WTO, World Trade Organization. So it is an international legal agreement between all the member nations which are of WTO. Now, what is a major reason, what is a major impact, or you can say that why TRIPS has been important? So TRIPS has been important because it focuses upon, like, there are certain factors such as it tries to minimize the standard of the regulations by the national government on any forms of intellectual property which is applied to any other WTO member nations. So TRIPS, basically, it is trying to create a regulation, it is trying to impose the standard on any form of IPR which is applied to nationals or any of the WTO member nations. Like in Doha Declaration, you can say that the Doha Declaration, which has been one of the declaration, which is a WTO statement, and the scope of the Doha Declaration satisfies and has focused upon the TRIPS. It has stated that TRIPS should not, can or should be interpreted in the light to promote the medicines for all. So it is very important that we need to promote and enhance the medicines. There were certain declarations, there were certain kind of agreements which has been made in relation to the TRIPS agreement. So in 2001, in the year 2001, there were the developing countries which concerned the developed countries, which has insisted over narrowing readily the amount of which has been the years which has been put up before in relation to TRIPS. So there has been the roundabout talks that has created the Doha Declaration. So there were the developing countries that has concerned the developed countries, which has insisted on an overly narrowing, or you can say that it has been reading on the TRIPS agreement, which has created the concept of the Doha Declaration. Now, moving ahead to the very next slide, that if we talk about the status of GI registrations in India. So GI registrations in India, there has been around 65 GI Indian origin, which has been registered with the Geographical Indication Registry. Also, these GI, there are certain examples which I have put forth before you. We have just now discussed. So you have Darjeeling tea, you have Ponchampalli textiles, you have Chandeli saris also, you have Kanchipuram silk also, Kashmir, Pashmina also, Kondapuli toys also, also Mysore agarbattis. So Kondapalli ties or Mysore agarbattis has been the part which has been given the status of geographical indication registration in India. So GI, we have already discussed the much information. Now heading towards the very next topic, when we talk about industrial design. Okay, so everybody has heard that what is design. So you can say that industrial design creates the applicability. It is a form of art, right? It is a form of applied art which is given of creating the aesthetics, or which is given to create the any kind of the design which has to be created in the form of the product. So the role of industrial designer is to create and execute the design, or such design is to be in the form of the product, and the product has to be mass produced. These products need to be mass produced. Maybe it must be improved for the marketability, it must be improved for the production. Also, that product must have certain kind of a sale, it must have a certain usability, it must have a certain agronomics or engineering or market. So industrial design is concerned with all human aspects, all machine aspects, all human aspects of machine man-made products. So industrial design, whenever you are creating a design to a certain product, and that product must inculcate, have certain human aspects to it, or it is creating a product which is also equivalently important and creating a relationship between the people and the environment. Also, these products are contributing somehow or impacting the nature or the society. So societal benefits are equivalently important. Human relationship between the product and the people and the environment is equivalently important. Also, it is giving a such form of maintenance in the form of the cost. So industrial design, you can say that it deals with the consumer products, or you can say that industrial products. So industrial design is a concept which has been revolving around the industrial products. So industries, you can say that, has been like creating the products in such a way that the designs have been given or designs have been assured. Now talking about the history of the industrial design, so till now, is there anyone who has been like facing any trouble in understanding any of the concept? Is there anyone who is facing any trouble in understanding any of the concept? You may please raise your hand. Okay, fine. See, when we talk about the history of the industrial design, so the school of the Saint Peter and Lorenz was found about 1750, and for the instruction of draftsmen employed in preparing the patterns of the silk manufacture. Also, Christopher Dresser is considered as the world's first industrial designer. So, industrial design has been designed just because of creating or giving the product a certain form of a design. Also, to make sure that that product is to be of some nature which has a certain value to it. Right. So moving ahead to the very next slide, keeping of the types of the industrial design. So industrial design, you can say that there are four major design which basically revolves around certain areas. So it basically focuses upon the human behavior, human machine interface, environment, or the product itself. So there are certain factors which the product itself or the design itself has been focusing upon. So you can say that human behavior is a very major factor. Also, human like design is a very major factor, that that product is creating a certain kind of applicability, certain kind of innovation, certain kind of practicality, or the environment. It has to be environment friendly. Also, it should not, there has to be a right which is to be given, that a right to forbid others from producing, selling, or importing the same product. So for the same outlook, we have given the period of 25 years, which is the basic minimum year for 25 years. The product need not to be used by any other company, by any other user, and there is a minimum duration of protection of the industrial design. So, right, you can forbid the person from producing, selling, or importing the product for the period of 25 years. Also, there are four major factors or four major design research activities which is related or revolving around the human behavior, human machine interface, the environment, the product itself. There are certain factors which are associated with the same. Now, talking about in the Indian context, we have currently the Indian Design Act 2000. So, Indian Design Act 2000, it consists or comply with the articles 25 and 26 of the TRIPS agreement. So, the act has been majorly consolidated to amend the law to comply the articles which are given under the TRIPS agreement, that are 25 and 26 specifically. The new act now defines design, like there's a certain definition of given, like there's a certain perspective, there is a certain definition which has been given to like what is design. So when we talk about design, so design consists of the features, shape or configuration, pattern, ornament, or a composition of lines or colors with two or three dimensional forms, or you can say that whether manual or mechanical or chemical, separate or combined. So anything which is comprising or which has a certain shape, which is forming a certain shape, which has a certain configuration, which has certain manual or chemical separate combined thing, then that thing becomes design. So there's a principal mode of construction of the creation of the design. Now moving ahead to the very next concept, that what is patent. We have discussed about geographical indication, we have discussed about just now about what is design. Till now, is there anyone who is facing any trouble in understanding any of the concept? Students, you can meanwhile put up your questions on the chat box, in the chat box.
If anybody have any query till now, you may write in chat box.
Okay, fine. Now moving ahead, when it comes to the patent. Okay, so patent, anything which is new in nature, which is novel in nature, or anything which has a subject, patentable subject matter. So you can say that patent are the specific rights which describe about the invention, which describe about the specific thing which is new. It has to be novel. It must contain certain applicability. It must contain the manufacture. It must contain the process, which has to be useful in nature. So anything which is not useful in nature will not be considered as a product, right? So anything which is useful in nature, which is very important, which is creating the invention, which is preparing a drug, and that particular drug, that particular invention must have a certain applicability. Industrial applicability is very much important. How much it is contributing to the society, how much it is contributing, how much contribution is for the economic growth, how much contribution is for the progress of the society. These factors are very, very important in nature. So there are patentable subject matters such as the inventions related to the product or process or both, which must involve an inventive step, which must be capable of industrial applicability. There must be a machine. So whatever the thing it is, an inventor can always claim the exclusive right over the invention which a person, which an inventor has prepared. If there is a certain invention, then a patent is to be claimed by the inventor, and such person can claim and demand that from now onwards, I am I belong, I have created this particular product, such particular product or invention belongs to me. But the onus lies on the patent office to grant the patent. Right? There's a proper process to it. We'll be soon conducting the lecture that how the patent is to be granted. Now moving ahead, that what is the definition of the patent? So invention must not be published in India or elsewhere, or prior public knowledge or prior public use within India claimed before any specific specification in India. So publication, firstly, invention must not be published in India or elsewhere without the prior knowledge. So prior knowledge has to be given, then the patent is to be granted. Then the term for a patent. Then what is the term for the patent? The term is for the minimum 20 years. And from the date of filing till all the types of inventions, the patent is to be granted. Also, the priority date and the first to file is also to be ensured. The date of filing of the patent application for the patent is to be ensured. The term for the patent is counted from this date. So the moment you are creating the filing of the patent application, and that from that day onwards, the term of the patent is to be counted from that particular date. Now, moving ahead to the very next slide, that firstly, as everybody has understood the concept, that patent is to be granted for the period of 20 years. So minimum year is the 20 years from the date of filing all types of inventions. So 20 years is the time period which is fixed and has to be granted for the inventions. Now, why the patent is to be important? Like, is there any reason that why are we like focusing upon the patent information? There is a certain information, there is a certain research work which prior goes hand in hand. So you can say that we as the innovators, inventors, or creators are focusing upon that the duplication of the research work is to be avoided. Also, we need to be readily ensure that we need to find solutions for all the technical problems related to the ongoing research. So business enterprises are there. We need new products for the marketing. We need to find out the patent owners. We need to consult the research and development financial institutions for ensuring the important information which belongs to creating the patent or which belongs to granting the patent. Okay, is a patent, now question here is a patent which is granted in one country can become enforceable in another country? No. The answer to this question is no. There is nothing like a global patent or a world patent. Patent rights are essentially territorial in nature. Okay, so there is no such concept like of a world patent or a global patent which has been specifically given. Also, granting a patent in one country of the union does not force the other countries to grant the patent for the same invention. So you can say that granting a patent which belongs to one particular country or the union does not force the other country to grant the patent for the same invention. Also, there is no such concept of the global patent or the world patent. And patent rights are essentially which are the territorial in nature. It is considered as a territorial right. Also, the refusal of the patent in one country does not mean that it will be terminated by the all other countries. If one country is not granting the complete patent, that doesn't mean the other countries will not grant the patent. Patent is not to be granted by the other countries. It can be granted by the other countries. If one country has been completely and blatantly denying of granting the patent, then there's a huge possibility that the other countries can also grant the patent. Now, the scope of patentability under the Patent Act. So when we talk about the patent, so section 2 clause 1 subclause J defines about invention. Okay, so patent, you can say that it is to be defined under certain steps that how the patent is to be granted, or you can say that the scope of patent revolves around certain areas. Then what is invention? Invention means that whenever you are creating a new product, that involves an inventive step. But what is inventive step? That invention must have to be new. That invention must have to be novel in nature, and it must have a certain industrial applicability. That whatever the patent which is to be prepared, whatever the patent which is to be created, rather than prepared, it has to be created, it has to be innovated, then that particular product must be utilized properly. It must be utilized, it must have a certain industrial applicability, that it should contribute the economic growth. It must also, if either it has to be like the invention must not be published in India or elsewhere, then there's a prior public knowledge or prior use within India must be claimed within a specific territory of India. Also, there must be an inventive step. But what is inventive step? Inventive step is something that you can compare to the existing knowledge, that it has to have the economic significance. Economic industrial growth is very important, and the person who is involved in that particular uh, creation of the patent or in that particular invention, if there is an invention which is to be introduced in the market, then that particular person should not know about that particular invention. So there must not be any prior knowledge, there must not be any kind of information which is to be known to a person who belongs to that particular invention, who belongs to that particular skilled art. Okay, if there is a person who has created the invention, who has created any kind of innovation, then that particular product must not be known to a person who is already involved in that particular skilled art. Then like documents, how the documents related to the patent filing application can be made. It can be made through the online application mode through e-filing, that is www.ipindiaonline.government.in, online through online mode. So you can even jot down this website. If at all you have created something, if you have created the innovation, if you have made the innovation, then certainly you can switch to all these websites and you can access the same. Also, you can post the information through post, and it can be submitted by hand also in the patent office. Now, when we talk about patent office, so there are few patent office in India as well, where you can specifically post the information and you can utilize the benefit of it. Now, filing of the patent application, there is a certain process to it. Publication is to be given for the period of 18 months. And then there is a process of request by the examination. After the request, there's a refuser also who has, if there's a particular patent which is to be existent, then if there is a person who wants to object for that particular patent, then there is a refusal, there's a grant which is to be claimed. Also, the decision is to be finally made by the controller. But prior to that, there must be a post-grant opposition or on the grant of the patent. So there is a certain step to it, how one by one you will move from one step to the other step for filing and obtaining the patent. Now, moving ahead to the very next topic, that what is copyright? See, when we talk about the copyright, but before that, I just want to ask the students and if any person who is a research scholar, if you have any doubt, you may ask. Yes, Shifa.
I would
Yes.
suggest that we wait till the question round. Like once you are done with the presentation, you can just ask me and I will commence the round. And I would also like to encourage our participants to just, take part. Okay, guys, please.
Yes, for sure. So Shifa Sheikh has a query. She is insisting for uploading the PPT on this group. Yes, sure, Shifa. I am going to certainly update the PPT on the group. Okay. Then any other doubt? Okay. Okay, fine. Now moving ahead to the copyright. See, when we talk about the copyright, as we just now discussed, it is focusing upon the literary works, it is focusing upon the artistic works, it is focusing upon the dramatic works. So these are some of the specific areas, like be it literary works, be it like novel works, be it like artistic works, or be it like dramatic works. Copyright is majorly focusing upon these areas. Also upon the architecture, if you have written a book, if you have written the article, you can, if you have written a poem, if you have made any article in the newspaper, if you have prepared the computer program, you can surely and certainly claim the copyright. Now, why copyright is important? So copyright is a monopoly right which has been restricting and restraining that right from conferred owner of the copyright. So you can say that copyright, it is not a negative right, but meaning thereby that it is prohibitory in nature. Once you have written any book and you have claimed the copyright, then any other person cannot copy your work. So duplicity or duplication is not allowed whenever you have prepared or written any book, whenever you have written any article, whenever you have prepared a research work, then it is very important that that particular product, that particular book or that particular poem must be not to be copied by any other user. Okay. Also, the moral basis of the copyright, it is in the eighth commandment, that is, thou shall not steal. So one should not steal any other work. Okay, if you have created something which is original in nature, and when it is important that if you have created something that which is very natural, which is very original, and it is not involving any sort of duplicity, then surely and certainly you can claim the copyright on that particular product or on that particular uh, be it like books, be it like literary works, be it like computer programs, be it like artistic works, or be it like dramatic works. So, in these particular areas, you can certainly claim the copyright. So, in India, we have in the Copyright Act 1957, which has been amended recently by Copyright Amendment Act 2012. And this act has been applicable, like Copyright Act 1957 has been applicable from 21st January 1958 onwards. Also, you have like seen and talked about the Berne Convention. You have ensured that there are certain prospects related to Berne Convention and the Rome Convention, which talks about the origination of the copyright law. So, copyright law has been made, originated, or it has been ensured, it has been given the presence in the Berne Convention, in the Rome Convention. Also, initially, India was not a member of WIPO. Copyright Treaty, India was not definitely a member of WIPO. And WIPO Performance and Phonogram Treaty has been subsequently entered in the year 2013. Also, when we talk about the copyright, so there are certain terms of the copyright. When we talk about copyright, copyright is granted for the period of to last for the period of 60 years. Okay, so it is counted from the death of the author, and it has been basically granted for the literary work. If you have created any kind of literary work, if there's a dramatic work, if there is a musical work, if there's an artistic work, and copyright in the paradigm of the publication in the area from the date of publication, which has been granted for the cinematographic films and sound recordings, photographs, posthumous publications, works of the government and international organizations. This copyright, these are the specific areas where the copyright is to be granted with from the date of the publication. But in the areas of literary works, artistic works, or the dramatic works, copyright is to be granted from the death of the author. So there's a specific differentiation to it, that copyright is counted in the specific areas from the death of the author in the areas of literary works, artistic works, dramatic works, and musical works. But in the areas of cinematographic films, sound recordings, photographs, posthumous publications, government and the international organizations, government works of the government and international organization, it has to be counted from the date of the publication. Okay, now the copyright has been, like, we have already talked about copyright in a brief and a very in an overview manner. Now switching to trademark. Okay, so when we were earlier discussing about the trademark, the background of the trademark revolves around the Trademark Act 1999, which has given the exclusive right to the brand name. So if there is a certain brand name, brand value, then there's a, you can see that there's a TM written. Okay, trademark. So there's a mark to it. That today's consumers are very much brand oriented and they are focusing upon the original brand hugely. It is very important for them that they have been focusing upon the brand, they have been focusing upon creating and building a market. So for this, here trademarks come into existence. Also, you can say that a trademark is a word. It can be a word, it can be a symbol, it can be used by an individual or a business organization. Okay, And once a registered trademark is designed or registered, so there's a R symbol to it as a registered mark, as a registered trademark. And the certificate of the trademark registration provides the exclusive right to the proprietor. So once the proprietor has claimed for the right, once the right is to be given, then afterwards that particular individual can claim the particular brand, can claim the particular word, can claim the particular unique symbol as the trademark. Now, why the trademarks is important? Switching to the next slide. Why trademarks important? Trademark is important because it wants to enhance the quality, it wants to enhance the uniqueness of the trademark, and it is to be granted for the period of 10 years. So 10 years, it's a minimum duration.
Ma'am is rejoining in 2 minutes. Just wait.
Am I audible?
Oh, yes, ma'am, you are.
Okay, okay. I'll again share the screen. Just give me a second. Yes, I just hope my PPT is visible now. So when we talk about the trademark has been given the right for the initial term of 10 years. So 10 years is the term where the trademark has to be registered, and it has been given the initial term for the registration for the period of 10 years. And after the period of 10 years, it can be renewed from time to time. Like we have seen that in the scenario of patent, it is to be given for the period of 20 years. In the scenario of the copyright, it is to be given for the period of 60 years after the death of the author. Similarly, the trademark is to be registered for the initial period of 10 years. Also, like why trademark is important? Trademark is important because it is created as a statutory right. Okay, it is treated as a statutory right, and trademark is also important because here the brand value, the brand name of that particular symbol, logo, is to be ensured, is to be claimed, is to be acknowledged. Okay, a trademark is a type of a mark or the intellectual property which is consisting of a recognizable sign. It must have a certain expression. It must have a certain product or a services. You can say that that services or a trademark must usually contain certain service marks. So now we are done with all these slides, and I really want to thank Dr. Prashant L. Pingley for the resources which I have used. So always it is very important that whenever you are taking help from any of the resources, you're always thanking that individual. So I want to thank Dr. Prashant Pingde for the resources, because resources, be it like thanking one for the book, if you have read or any book and you have taken the quotation from any book, it's very important that you are particularly given the acknowledgement, you are thanking that particular individual. It is very, very important that you are thanking that individual, and that's how things work. In the area of copyright, patent, trademark, and majorly it is known as intellectual property rights. Any confusion, any doubts? If you have any doubt, you can post it in the chat box. I'm very much keen to address the questions.
I would like to inform all the participants that the question round is on. So you all just post your questions in the message box. And meanwhile, I'll just inform you all that Legal Vidya is gonna present two courses. First is the certificate course on the NDPS Act, which will be providing a comprehensive understanding of India's drug control laws. Now, it will be focusing on key provisions, enforcement mechanisms, and judicial interpretations. It aims to equip legal professionals, students, and enforcement officers with the skills needed to handle issues related to narcotic drugs and psychopathic substances. The course will be led by Ms. Nivedita Kondinya, an accomplished law professional with extensive academic and practical experience. So registration is will be closing on 5th July and will be the course will be beginning on 6th of July. And the second course is on the certificate course on moot courts. Now, it will be equipping the participants with essential skills in legal research, drafting memorials, and oral advocacy through realistic courtroom simulations. Now, it will be led by Ms. Madhavi Datta, an experienced law professor with extensive moot court involvement, and the course aims to enhance litigation skills and legal practice. Registration of it will be also be closing on 6th of July, and it will begin soon. So, thank you. And I request ma'am to address all the questions if there are any.
Students, if you have any questions, any doubts, students or research scholars, if you have any questions or any doubts, you post that in the chat box and I'll be happy to address all those questions.
Vaibhav, if there are any questions, kindly read for the map.
Ma'am, Aliza Rao asks that why there has to be a duration for IPRs, like when one is innovating something for the sake of their own interest.
Okay, please repeat the question again. Please repeat the question again, Vaibhav. I'm not able to see that in the chat box.
Sorry. Aliza Rao asks that, ma'am, why there has to be duration for IPRs when one is innovating something for the sake of their own interest.
Okay. Very good question, Aliza. When we talk about the creation, when we talk about the innovation, so it is not that every individual is to be given the particular innovation till he's going to die. Okay. It is not in any case, in any scenario possible that the person is going to be like getting the advantage till his death. Okay. So it is very important to ensure that if there is an innovation must consist of a certain duration, right? If there is no such innovation, then how would duration be existent? Okay. If there is an innovation must consist of a certain duration. For an example, if we talk about there are certain pros to IPR, there are cons to it as well. If there are certain alternatives which are protecting and promoting the IPR, also intellectual property right where it has been the trademark, where it has been the GI, it is to be renewed from time to time. Okay, it is not that the person is to be given the particular specific thing for the lifetime duration. It is important that that particular product, that particular innovation can be renewed from time to time. Maybe in that particular scenario, anybody else who has prepared a genuine product, who has created a genuine advantageous product in the market or innovated something, then it can contribute much for the society. So depending upon that which particular IPR is it, be it like patent, be it like copyright, be it like trademark, or be it like GI, depending upon the quality, depending upon the necessities of that particular product, the specific duration is to be granted. So, like for copyright, we have granted for the period of like 60 years after the lifetime, the death of the author. So, there is a certain way to it, because if at all the people will be start using that particular product, it would create amount of duplicity. Okay, so in order to remove the duplicity, in order to remove any kind of undue infringement, that is where the years are specifically granted, that after the completion of that particular year, then maybe in that scenario, in that situation, again the product can be renewed, or again the right, or the years can be re-again granted. So it is very important that to grant those specific years, we need to be ensured upon the same. Yes. If suppose a person writes a book, does he or she needs copyright for the same? Absolutely, Prashansa. Absolutely. In order to protect your rights, you need to firstly fill the copyright form. Once you have filled the details of the copyright form, that copyright form is to be attached even in your book also. That from now onwards, I am the author of this book, and nobody has a right to create the duplicity. No one has a right to create the infringement of my self-authored book, right? So it's very important to reduce the amount of duplicity. You are supposed to get the copyright, and you have to fill the details of the copyright form, and you have to attach with the same. Yes. Anybody else who wants to have the question?
Ma'am, Nandini Sharma asks that why patent is not granted on atomic energy related inventions.
Okay. See, firstly, atomic energy related issues basically are really threatful. So at times, if once the patent is to be granted on these specific areas, the government will not be able to approach. Okay, so these are the guidelines upon the government, that the government is going to take a hand over it. The government is going to be responsible for the same. So if government is taking the kind of benefit, the kind of advantage to it, that is why the areas related to atomic energy has not been granted the patent. So it is the government which is responsible, because the amount of contribution which is to be made by any other person in relation to atomic energy is to be submitted for the government. Yes, anybody else?
Ma'am, Advocate Jeeva Das is asking that is there any specific area to practice in this law? If it is, then how would we approach with it as professional medium?
Okay. Basically, there is a patent attorney exam which you can give, right? So, like, if once you clear this exam, then after that you can specifically work in the area of the patent. So even if you are willing to work, even if you are ready to work the opportunities related to the patent, so you need to qualify the exam, right? So the exam comprise, it is not, you can say that the exam is not very, very difficult, but at least the basic amount of knowledge, at least the basic amount of the information is to be required. So if you can say that if you have once qualified the patent registration exam, then you can specifically work in the areas of the patent registry. You can specifically work in the areas of creating that how the patent is to be ensured, how the patent is to be like examined, All these specific factors, all these things come under the area of patent registry exams. Once if you have cleared this exam, you will get a line of length of it. Yes, anybody else for the questions?
Ma'am, I have asked one question. Would you please care to answer it?
Okay, subconscious plagiarism. Okay. See, subconscious plagiarism is at times not ignored. Why it is not ignored? Because see, there are times when you, being a lawyer or if a person who belongs to the legal world, legal arena, if the person has a legal knowledge, okay, then you cannot surely, you cannot certainly ignore the subconscious plagiarism. If you do not have the legal knowledge, if you are not doing it, purposely, if you're not doing it intentionally, then it can be ignored. Okay, but like, why to go for subconscious plagiarism? That's a question. Okay, you do not need to go the subconscious plagiarism whenever you are copying something from any information. If you are copying any article, if you are copying any kind of PPT, like just now I have had the share of information from the particular resource person. So I have immediately given the name of that particular individual. That is why there are footnotes. That is why there is so much of research work which is to be involved. Okay. Whenever you are taking the information from any source, from any website, and you have to put up that particular information, always give the source, always give credit to the particular individual who has created that information. Yes. Is there any other question?
Samruddhi Nayak asks one question. She asks, ma'am, copyright is protected upon its invention and later they are advised to be registered. Then why this is not the case for other types of IPs? Why they are not protected upon its invention?
Okay. See, when we talk about the copyright, there are incredible chances. Okay, there are incredible chances that it can be, there is a process of duplicity, there is a process of duplication involved from the commencement. Okay, because once if you have written something, then there is a high chance of duplicity. Whereas there cannot be high chances for the other IPRs as well. This is the major reason why they are not protected upon its invention. Anybody else? Alfiza Rao. Then can't the IPRs for an indefinite period of time? No, beta. Alfiza Rao, no. It cannot be the scenario. It cannot be the case that the IPRs can protect it for the indefinite period of time. There's a certain duration to it. Patent has to be granted for the period of 20 years. Copyright for the period of 60 years after the lifetime of the author. GI, there is a certain duration. Then trademark, has to be period for the 10 years. There's a specific duration involved for a specific IPR. Any other question? Okay, thank you, Alfiza. Yes, over to you, Vaibhav.
So I guess, ma'am, we are done with the questions, and I would like to give a personal remark that it was really insightful. Thank you very much.